Okay, so this is Jen the Liberty Lion, and today we're going to look at a book by Stephen Sheffer called Meaning. I apologize in advance for the noises. I'm in the middle of dinner and dishes. So I really don't recommend this book for reading pleasure. It's a little bit of a difficult read. If you like reading philosophy and you're used to this kind of thing, he speaks, I call them like equation type language, and it's this way through the entire book is this way. So I'll read you a little portion of how he's writing in this book, and then you'll know why I don't recommend it. Okay, so he says, there may appear to be two candidate responses in the case where S argues that P from certain known premises. It has been suggested that while in this type of case, S does not intend to get A to believe that P by means of recognition of intention, S does intend A to think that S thinks that P, and does intend that at least part of A's reason for thinking that S thinks that P be that S intends A to think that S thinks that P. Perhaps the suggestion goes, this is a book on meaning, S means that P in virtue of his intention to produce, and on and on and on. So, okay, so if you don't read philosophy, or you're not reading things on logic often, you probably won't like this book. So that's the only reason why I don't recommend it. You can buy it and read it whether I recommend it or not. So if you want to read this book, go ahead. It's Stephen Sheffer, Meaning. Okay, I'm going to just sort of very, very extremely briefly, maybe too briefly, go over my interpretation of what he's saying. So at least in having to do with intention of what we say. So, okay, so intentions matter. It has been said, this is just me writing, okay? It has been said by various writers on language as well as philosophers that there are problems with language, particularly they speak of English language. A reason is because it is nearly impossible to tell the difference between what is said scientifically and artfully. So what I'm saying is that there's several writers on the English language that have written this in their book, that they say that if you're writing scientifically and you're writing artfully, there's no way to really tell the difference between what's being written. Is it written artfully? Is it written as fiction? Is it written as a fact? Is it written as truth? There's no way really to tell. We have no keys to our language to be able to say for sure that something is written meaning this way or this way. He says a fiction, or my notes are that a fiction may appear as a nonfiction, a lie may appear as truth, truth may appear to be a lie, reality and statements of it are subjective, but a concrete statement or fact may be no actual fact at all. And I've read also in several of these books that a statement can look to be either true or false, but be neither true or false. Okay, so context does not always clarify the issue. Furthermore, there is meaning and what someone meant. Intentions matter. Okay, I've said this in some of my other videos. It's part of the law. Intention of the law matters. Intention of what you say matters. In this book, Stephen Sheffer explains that it's not what I say that is the truth of what I mean. It is my intention. It is what I actually meant. That is the truth, but is the truth what I meant? So maybe you've heard of the saying, I'm not responsible for what you misunderstand. Or my intention gives meaning to my work. My intention, okay? It's what I mean, not what you understand. And sometimes what I say is not what I mean, and what I say is not what you hear or understand. And what I say may not be what I intended. And maybe I meant something else. Maybe I said one thing to make you look over there, and really I meant something else. Maybe my intention is to deceive. Okay, so we look at that. In the book Meaning, he goes over various ways people say things and how the words are not what they mean. The intention is what is meant. Okay, so mean, meant, meaning, we're talking about what we mean. He shows by way, not exactly through examples, but by way of something like equations. One example, now I read to you how he writes. I'm going to read you another little section. I think it's on page 68. He says, we have now to consider certain alleged threats, either to the condition that S meant that P, but only if S intended to cause in A the activated belief, like thinking it right now. I activated your belief system so that you think it right now, that P, or to the condition that S meant that A was to phi, he uses the phi symbol, only if S intended to cause A to phi. Okay? Well, that makes sense of that. His book is written, and that way it's the whole book. So how do we know what is being said if we hear words, someone speaks or writes, but we do not or cannot know what the intention is? This is one of the advantages that lawyers have and politicians have over people, is that they have this art of being able to say something, you understand it as being A and they meant it as S, okay? Or you understand it as omega and they meant it as phi, okay? That's kind of the purpose, right? That's why we need them, because they have to interpret the law for us, because we got no idea what they're saying. And most of them have no idea what they're saying. So many written laws lack a clear statement of intention, or it is the intention's misunderstood, or the authority is misunderstood, or it's the wrong authority, so on and so forth. But the intention is one of the requirements for written laws. It is to state the intention. Without a clear statement of intention of a law, it cannot be said to have been properly made. It lacks an important part of the, what have we been talking about in the last videos? Procedure, clear intention. However, as I explore the book Meaning again, I find intention to be one of the key components to the point of anything said or done. If there's any writing that would require a clearly stated intention, one would think it would be the law. The requirements are the authorities and the intention, among other things. Bills are divided into sections, but the section we're looking at is the purpose, which states the situation or problem, which gives the intent for legislation. Sometimes intent is policy or purpose, is stated as the policy or the purpose. Deception can occur when they, or any speaker, does not want you to recognize an intention. Instead, they want to activate your belief system, or make you believe something right now as they're speaking. That's the active, they want to activate your belief, because then you turn off your thinking brain. You turn off your logical brain. Active, which is a form of emotivation, drawing you away from reason. It is one or the other, it seems, emotion or logic and reason. How many politicians have you heard who actually try to get you to think rather than draw up a belief or a feeling? It is one or the other, it seems. Okay, I already said that. If they use feeling, it's because for one reason, they don't want you to think. What Schiffer calls activated belief. He distinguishes the difference between by saying and in saying. Okay? By saying this, I want you to feel or believe a thing. By saying is what I say. In saying is what I want you to understand or perhaps misunderstand. By saying something, we intend something. By saying something, we mean something. What we believe or understand may be fiction because the intention may have been to mislead or deceive. That is, in saying something is what you believe. By saying something is their words. What we meant, we may not be, or what we meant may not be what we said when the intent is to deceive. So what our intention was to deceive sometimes. Many people lie or deceive, but when they do, what is it they want? What do they want you to believe? If you really, really listen, you might understand their true intentions or what they really mean and not what they're saying, not the lie, not the deception. In all writings, books, laws, journals, articles, etc., and all speeches and all verbal utterances, statements, etc., we should look for the intent. We look beyond the obvious emotional response and beyond the unobvious or hidden belief or emotional response to the actual intent. Is it in the actual intent, or it is in the actual intent, usually hidden, where we find true meaning? And this is where I'm going to read a different part of page 68. Okay, so this is like a script. There's two people, a reporter and the president. The reporter asks a question. The president accidentally answers it honestly. So the reporter, tell me, Mr. President, what prompted you to lower the draft quota for November? Mr. President, the election. Oh, sotto voce. I didn't want to let that out. Oops. Okay. There is an art and a science to language. We find some non-emotive writings by Eisenhower during his presidency. Okay? I like to read Eisenhower stuff. It's like my favorite. It's really not that difficult to understand a lie, to see it, to know it, to realize it. They usually involve emotives or emotional words and phrases because people tend to believe emotions first over their own logic. You've probably dealt with this where you felt something and you reacted and then you thought about it later and you thought, well, that was stupid. Or they believe their own or their own ability to think reasonably. Okay, so first logic, then reason. Okay, the true intention can then be more easily revealed when you think instead of feeling. Okay, so to see it, to know it, to realize it, to realize that someone is trying to strike up a belief system in us, which brings up an emotional response instead of thinking things through. Okay, so the point, intentions matter. Okay, and I've said this in several of my videos. Okay, intention matters. You have to look at intention. And as the presidency wars come up, I'm talking about presidency wars, not presidency and wars. I'm talking about one thing, the war for presidency comes up, and we hear all these speeches and all this talk and stuff. Think to yourself, are they trying to get an emotional response out of me, even if it doesn't at first seem like it is? Or is this president actually asking me to think logically about something? And I'm not talking about thinking logically about an emotional thing. I'm talking about just thinking logically about a thing. Okay, so what they say, the people running for office, matters. They will almost always use emotional pleas because mainly over large groups of people, they work. They always have, and until people change, they always will. It's difficult not to do something we have a habit of doing, okay? I understand that. We have a habit of feeling and not so much of thinking. There's no difference between speaking artfully or scientifically. So that's one of the main problems of language. And I read on English language. I don't read other languages, but English has been specifically mentioned in the books that I've been reading. So language, especially English, is almost always used to deceive. So now we have the language of judges. This video is basically over, but I wanted to read some quotes out of this book just because they're really good, and whether they apply or not, they're just good quotes. Okay, I'm just starting at basically a random page. This book is really good. I do recommend reading this book. It's super good. It's about how we have this problem with language. This is one of the good books, okay? The Language of Judges, Lawrence M. Solon. I've read that he was kind of a pervert, a predator type person, but the information's good. You don't have to like the guy, okay? It's almost inconceivable that someone could buy an insurance policy that excludes the insured from coverage and believe that he is not excluded from coverage. There's that word, believe. Okay? I'm just randomly, I've marked some of them, but basically I'm randomly just picking out some things, interesting things that they say. Requirements and contracts to arbitrate. Okay. The rule that ambiguity in a contract will be construed against the drafter is to be used only when there is no extrinsic evidence available to aid in the interpretation of the contract, or where the uncertainty cannot be remedied by other rules of interpretation. You're going to find in here they talk about writing things very specifically and how that's a problem. But if you're too vague, that's a problem. You can't be either way. So, okay. The legal principle that addresses this situation is called the plain language rule, or clear language rule, which states that when the language is clear, courts have no authority to go beyond the words of a statute or contract, but must apply the clear language of the document to the facts before them. which gives them incentive to pretend like they don't understand. If they have to come to a ruling and they pretend that they don't understand the language, they can come to any ruling they want. Okay, and that comes from other books. Let's see. Just a few things. There certainly can be such a rule of law, and the rule of law is the plain language rule. Legalese, you know. We do not inquire what the legislature meant. We ask only what the statute means. So that's a problem, because if you know what the legislative intent was and you think you're following the law, and then you go to court and the court says, well, we don't look at their intent, we just follow what's written in the statute. Well, now you broke a law, you didn't even know you broke it. And you thought you were trying to follow the law, but they don't care. It is thus possible to distinguish between events that form part of an action and events that are themselves actions. Well, that's something to think about. What is an action? Okay, since these cases were decided, the Supreme Court has refused to apply the plain language rule in some instances, while applying it enthusiastically in others. You can't win. You cannot win. If you go this way, they say, well, we're going to go this way. Nice. Lawyers are acutely aware that any ambiguity in a legal document can lead to litigation down the road. As we shall see directly, the effort is doomed to failure. Specialized legal writing, or legalese, as it is sometimes called, sounds so pompous and silly that it is now literally against the law to use it in certain contexts. For example, when you're writing a law for the military to follow, and the military people don't have legal backgrounds, I'm saying this because I've read it, specifically for the military. When you're in the military, they're not supposed to write legalese for the military to follow, because the military is going to look at it and say, well, what the hell is this? I don't know what this says. They can't follow the law if they don't understand it. This, he argues, this is just a different quote, this, he argues, has the unfortunate side effect of encouraging legal writers to believe that legal language is, by its nature, more precise than ordinary English. You'll have to go back. This is a quest for precision. You'll have to go back and read this book if you want to know more. One such term is the reasonable man, a fictitious person against whose behavior our conduct is measured to determine whether we should be held liable for having caused injury to others. The late William Prosser, the leading American commentator on the law of torts, noted that the conduct of the reasonable man will vary with the situation with which he is confronted. Under the latitude of this phrase, the courts have made allowance not only for the external facts, but for many of the characteristics of the actor himself, and have applied in many respects a more or less subjective standard. Other expressions, such as substantial and satisfactory, also have their place in legal writing, as Mellenkopf notes. We are thus left with a body of writing that calls itself precise, but reserves the right to be as imprecise as it wishes. When the situation calls for imprecision, this state of affairs is widely criticized by lawyers and non-lawyers alike. No shit. Who recognize much of legal language as arrogant and empty hocus pocus. As an initial example, we look to some detail at the attempt by lawyers and other legal writers to avoid using pronouns in order to add precision by reducing ambiguity. But what does that do? That makes it sound like all laws are to be followed by all people. because we don't know who the law's actually for. So now we're making it vague. We should not be surprised that lawyers hate pronouns. Pronouns have little inherent meaning, acquiring their interpretation from the context in which we used it. And what I said earlier, you can't always find the context. You can't always find what's meant by putting it in context. Look at the Constitution. The Constitution hasn't meant anything that any judge decides it means. Okay? The problem with pronouns is that it's not always clear from the language or even the context which of a number of possible antecedents is the intended one. What do we go for? Some people say you go for the last antecedent. Some people say no, you got to go to the first antecedent. So they just use whichever one they want, whichever one works best and gets them to a decision that they like. But there are factors other than gender that determine what possible antecedents of a pronoun are. By examining some of these, we can see how elements of legal syntax may best be seen as an unsuccessful attempt to reduce the extent of ambiguity of reference through peculiar syntax devices, which have a nasty legal flavor. Pronouns and the Fifth Amendment. A number of factors that contribute to the ways in which we understand pronouns show themselves in the Fifth Amendment to the Constitution. The relevant passage is presented below. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself. There has been a century of debate over the question of who or what counts as a person. A person. For purposes of deciding who receives the protection of the Fifth Amendment, just about every other concept in the Fifth Amendment has also received extensive attention in the courts. For example, the circumstances under which two prosecutions constitute double jeopardy, and the subject is the subject of a substantial body of judicial decisions. The extent to which administrative procedures count as criminal cases for Fifth Amendment purposes has been the subject of case law, and whether a grant of immunity from prosecution makes self-incrimination impossible has been an issue. But one question has not seriously arisen: the relationship between any person and himself. We can't figure it out. Okay, any person is also the subject of to be a witness against himself. Who is this guy? In fact, legal writers do try to avoid using pronouns and other such forms. They used it in the Constitution, though. In essence, the legal writers gives each party a number and then uses the number instead of the party's name to refer to that party. Okay, so I'm going to stop here because my stove is going off. I'm making bacon wrapped chicken, in case you're wondering. So let's go over this really quick. I put stars by this. For example, lawyers reading this book already know that to prove a fraud, a plaintiff must prove that the defendant acted with scienter, which is defined very loosely as intent to deceive. Of course, we could eliminate the word scienter entirely from legal discourse by passing a law making it illegal to use the word since it is not plain English, and substitute for it the expression intent to deceive in every instance in which scienter had appeared. However, intent to deceive is not really an accurate definition of scienter in all cases. Courts have interpreted the requirement of scienter to reflect different states of mind in different circumstances. And then later on, in the end of the paragraph, probably a more accurate definition of scienter is tautologically the state of mind required to prove fraud, which usually is intent to deceive. But like all tautologies, this definition tells us very little. Okay, so even the definition that we think will work best won't work. Okay, that's it for me today. I'm going to put this under our language deception podcast, and I'll have lecture 4 coming soon in the book, How to Do Things with Words. And this is just sort of an in-between video on intent. Okay? See you in the next video.